Hi Rina, my name is Darshan and I'm here with my three good members, Pardeep, Prabhkaran and Sangeet. So here we are going to record the presentation about legal aspects of international trade and enterprise. So our case is the Bhopal case where Charan Lal Sahu took petition against Union of India. So this case involved a review petition against Bhopal gas leak disaster which come under the Act 1985. So in this case, the central government of India decided to represent the victim in case against Union Carbide, the subsidiary of Union Carbide Corporation in New York. So as the massive leak of gas took place from company's planet, which killed over the thousand of people and thousand of people injured and affected as well. So the Indian Parliament enacted Bhopal Gas Leak Disaster Act 1985, which conferred on Indian government the power to represent victims in lawsuit. So this case was challenged by the Charan Lal Sahu, and he argued that the fact that the government brought the case against victims and did not allow them to bring it individually because it make it impossible to hear all of them individually. So it was necessary, like a doctrine of necessity, to let government bring case on behalf of them. So therefore the court ruling was based more on the concept of public policy. So there are some grounds of petition, and the issues were raised by the petitioner Charan Lal Sahu, which were that the first one include the act was not in line with the fundamental rights granted by Indian Constitution under the section 19, 14 and 21. So the second petition was act was not aligned with the principle of natural justice. So this was raised on the grounds that the Indian government was a joint tort feasor and thus did not have any locus standi on the matter because it was government which allowed the establishment of such factories without safeguards to protect against the likelihood of such incidents. So the third petition is related with the government did not have any legislative competency to ask victims to surrender their right by offering them legal aid. So this is my part, and the next part I ask my friend Prabhkaranjit to come and to represent. Thank you.
Hi, my name is Prabhkaranjit, and now I'm going to talk about the violation of fundamental rights. The procedure given in the Act compromised the rights of an individual in the Article 14, 19 and 21. Victims have fundamental rights under these articles to bring action against the company. The government rely on the concept of parents and patri means father of the country, whereby the government had the responsibility to protect people. So now after that I'm going to talk about the court accept the government claim of parent and patri and held that the victims cannot be considered to be any match to the multinational companies or the government with whom in the conditions that the victims or their representative was after the disaster, physically, mentally, financially, economically, and also because of the position of the litigation would have the contains, and in such a situation of predicament, and the victims could be legitimate by considered to be disabled. So after that, now I'm going to be invite my friend Pardeep to further carry on with the next points. So just Pardeep, come here.
Hi, I'm Pradeep. I'm going to start with the Act violated principles of natural justice. The first principle was the locus standi, that is sufficient standing to bring the case. So the since there was the principle starts with the principle of the locus standi entails that in order to bring proceeding, the party must demonstrate there was a link between the party and the and the incident and the harm suffered by the both suffered by the party. In other words, we can say that there was no harm was suffered by the by the incident and the harm by the party that proceeding may not be brought by such party against the perpetrators of incident. Therefore, on this basis, they argue that since no harm was suffered by the Indian government, therefore it didn't have a sufficient standing to bring the case against the company. So the government suffered no harm, therefore under local standing it cannot bring proceedings. The second principle was of the Trump here the other side. The court cannot give ruling on the matter without hearing with both victim and defendant. In either we can say the two parties is absent when the principle of natural justice or the ultram patrum would apply to prevent the decision on the basis of the sole hearing of one party. And the third principle was nemo dat in causa sua. No person can be judged in his own cause, since the government owned 22% of the shares in the company, which was responsible. Therefore, it was likely bring proceeding against itself. The natural justice is that no man should be a judge in his own cause, and therefore no such grounds the government was not competent to bring proceeding against the company, and in which the under 22% of the shares that they would tend amount to becoming a judge in his own cause. The principle of nemo dat in sua was not breached because the court referred to the magnitude and the huge number of victims and stated that a critical situation like that, it is the government which can be effectively bring proceedings against the company on the behalf wide number of victims. Moreover, the court also held the organization was dependent on the ownership of the government, and it was not the state owned organization. Therefore, the conflict of interest did not arise. In arriving at this decision, the court applied the doctrine of necessity, that in a situation like the involving huge number of victims, it was the government could effectively pursue the case. The company was not the government honored, it had private existence, then the principle was not breached. So due to the the government had standing to bring proceedings, the court held that the pre-decisional hearing is necessary to avoid the breaching or the Trump pattern. If no such hearing was given, then it amounted to breach. However, the act did afford some opportunities of hearing the victim before bringing proceeding against them. Therefore, the principle was not breached. So I'm just pass the presentation to my friend Sangeet.
Thank you, Pardeep. Now I'm talking about the third point, which is the lacking legislative competency. The first one is the ground. Government lacked the legislative competency to demand surrender of right from citizen in guise of guide. And the second one is the court, however, disagreed and stated that the government was laboring under the act which was in line with the Article 39A of the Constitution. This article provided the legal and legitimate basis for the government to act on the behalf of the victims. Therefore, the government was legislative competent to bring such a case. Now I'm talking about the conclusion, and the conclusion is for this case represents a unique case where the concept of public policy or doctrine of necessity over the individual right. However, the right was not strictly compromised, as the government brought case against victim and afforded them legal aid as well. Therefore, the case was unique as it gave effect to the public policy more than strict individual right. However, the court did just suggest whereby such situation can be dealt with in future. All the judges proposed a common fund which should be established by company that are involved in the hazardous activities such as the current company which was making pesticides, such fund would go to gather mitigation against such incidents. So this is our presentation. Thank you.